will be with you in about 2 minutes. Good afternoon and welcome to Helping Boards Navigate Difficult Legal Issues. This is a webinar that's presented in conjunction with the Wilkin and Guttenplan Professional Growth Academy, and I'm looking forward to this webinar. My name is Jules Frankel. I'll be moderating the session today, and our speakers are Hubert Cutolo. Hubert is with Cutolo Mandel and has significant experience with numerous associations, and Karyn Kennedy Branco, who is a partner in Kennedy, Wronko, Kennedy, who also spends a significant amount of her time in the community associations world. First, some housekeeping. If you want to ask us any questions, please use the questions pane in the GoToWebinar dashboard on your screen. We will try to answer as many questions as possible. Throughout the webinar, we will have a few polling questions. This will help us get a sense of the webinar participants and their experience. This webinar is being recorded and will be uploaded onto our website at www.wgcpas.com. Within the next day or two, we'll be sending a survey to you. We would greatly appreciate if you would give us your feedback and return it. We really value your comments. Our topics. We've divided this session into 5 different areas. The first area will be open meetings and questions related to open meetings. Second area will be disclosure of financial information. The third is board member roles in collecting owner assessments. We're not going to be covering the collection process, but rather what's the board member role in this process and what are some of the legal pitfalls to be avoided. How to obtain membership buy-in in various decisions. And lastly, best practices on holding elections. To start, we would like you to let us know who you are. So we're going to poll the audience, and we'd like to know what your role is, whether you're 1, a board member, 2, property manager, 3, a professional, or 4, other. Please take a second and indicate who you are. Okay, I see that approximately 2/3 of you are board members and approximately 1/3 of you are property managers, so we know who's in the audience today. So we're going to start with the area of open meetings. Boards hold open and closed meetings. First question I'm going to address to Hubert is, what's the law in New Jersey on open and closed meetings, and what's the difference between an open meeting and a closed meeting?
Thank you, Jules. The major difference is obviously under New Jersey law, which is both PRESTA, which is the Planned Real Estate and Development Act, and the New Jersey Condominium Act. The associations are required to approve all of the decisions that they're making within an open board meeting. There are certain areas that are excluded from those votes, and those deal with basically 4 different areas within the Condominium Act. Anything which would create an unwarranted invasion of privacy, so you're not discussing, obviously, individual unit owner information. Anything to do with contract negotiations, but also keep in mind with the contract negotiations, after the contract is fully negotiated, the board would have to vote to approve that in open session. The other areas that are not covered, and these are all within the Condo Act that you would not have to vote on in an open session, is anything involving the attorney-client privilege and anything dealing with the employment of employees by the association. Otherwise, every decision by the board has to be approved and voted on in open session, and meeting minutes have to be kept. Oftentimes, boards will discuss other issues in closed session. Closed session is typically executive session where the board can have a very candid discussion on how they come to their decisions that they don't want recorded in meeting minutes because it could potentially prejudice the association. So ultimately, a board will have those candid discussions in closed and deal with any of the aforementioned categories we just mentioned, and then will ultimately vote to approve those decisions in open session.
So Karyn, are there any other topics or materials that should be approved at an open meeting, let's say the audit, for instance? And are there other items that should absolutely not be discussed or approved in an open meeting that Hubert just spoke about?
Thank you, Jules. This does follow on what Hubert just spoke about. What we should be discussing at meetings, what we shouldn't be discussing, is what Hubert had enumerated that's well within the Condominium Act, the Planned Real Estate Disclosure Act, which governs the homeowners associations, and also the Open Meetings Act. They all have substantially similar language. The things you should be discussing, obviously, is everything that's not privileged, everything that shouldn't be done within a closed session. So you should be discussing, as Jules says, definitely the fact that you're going to have the annual audit, what goes into it, give notice as to the progress, how it's been coming along, and tell people when they can expect for the annual audit to be complete and when they can receive or otherwise access copies. As Hubert said, contracts, once they're completed, should always be available for discussion and also for review at the meetings. The things you don't want to discuss would be things such as certain personnel issues, where people do have an expectation of privacy. You don't want to be discussing anything that has to do with litigation strategy. My firm does a lot of the defense work, and I often have to counsel associations, the board, the managers, when they haven't been involved in litigation before, as to certain protocols as what can be discussed, what cannot be discussed. When it comes to litigation, if an association is being sued or the board is being sued, we often tell the board very little can be discussed because everything could impact the outcome of the litigation. Other than that, everything that's not privileged should really be discussed at an open meeting if it's an action item.
So if I'm going to present a draft of the audit to the board for approval before it gets finalized, do either of you have thoughts as to whether this should be done at an open meeting or at a closed meeting?
We would always recommend, Jules, that it be done at a closed meeting until they vote to approve those audited numbers. The board should be given an opportunity to address any issues. I know Wilkin and Guttenplan is very thorough, and obviously the footnotes they're putting together, and we'll oftentimes have questions to the board and the representation letters that need to be signed as well. So those issues will commonly be dealt with in closed, answered, and then once the audit is finalized, the board will vote to approve that audit and then make that available to the membership.
Do they vote to approve it in open session or in closed session? Or does it matter?
Once all of the issues are worked out, they do have to vote to approve that in open session and then make that available to the membership.
So under the topic of peace in the house, for lack of a better phrase, since I know you've never been to any contentious meetings. What is a homeowner's role at an open meeting? What are they allowed to do, or are they basically just sitting there listening to what's going on? Hubert?
Jules, they typically are. I mean, a board or an individual member of an association does not have a right to speak at a board meeting. A board meeting is the board going through, voting on all of their decisions, and then that does get memorialized into meeting minutes. Most of the associations, and we will make a differentiation between regular meetings and annual meetings.
Go ahead.
Because regular meetings, it is just a board meeting. The members don't have a right to actually speak during the meeting. Most associations will have an open session at the end where unit owners or members can ask questions and then the board can respond to them. We always try to create a professional atmosphere. And for all you board members and managers that are listening, you've probably all been to the very difficult meeting where you have the one unruly person. We always try to be, or recommend that our boards and management companies be as transparent as possible and try to be respectful and courteous, although sometimes the members will not act towards you in that way. If members are not behaving at that meeting, you obviously can ask them to potentially leave and not attend the meeting anymore, but there is no right for an individual member to speak at any board meeting. Now, that is different than the annual election meeting, which is actually a members' meeting. And at those meetings, the members can typically make motions from the floor, and it's actually a meeting of the members and not the board. Though I don't know how much you want to, I don't know how much you want to advertise that, because oftentimes the board will give direction within the annual meeting, will make the necessary motions, and try to keep control over that meeting.
So Karyn, can a unit owner walk in with a video recorder or an iPhone and sit there and record the meeting? And if they can't, what do you do if they refuse to stop?
Yeah, that's a fantastic question. I wish you had asked me this 10 years ago, before we had to worry about perhaps Google Glass or iPhones. I question now how substantively we can actually prevent people, at least knowingly, from recording the meetings. I am not a fan of the meetings being recorded, other than if an association or its management company is taking an official record of the particular meeting. Some associations do like to have a videotape recording of the meetings. They can play it on a channel, maybe a dedicated cable channel. That's okay, because now you have control over the recording. If you allow other people in the audience to take recordings, a couple different things can happen. One, somebody can put it out into the public. They can splice it. They can do all sorts of things with a copy of the recording, and now you have to disprove that that's not a true recording. I say no, I would have the person leave if we can find out. But again, I think it's a very difficult issue because there are all different types of devices where we may not know if somebody is actually recording the meeting. Would you agree, Hubert, in terms of the different devices?
Karyn, I would. I mean, it would certainly be difficult to know if they're actually taping. The boards may wish to promulgate some type of policy with regard to potentially recording the meeting, so that if a member looked to record it, you could point to a specific resolution that says there will be no recording.
Does your answer change whether it's a board meeting or whether it's an annual meeting?
My answer wouldn't change. I would take a uniform policy in that regard. To the extent, once again, the association and or through its management company wants to have a recording, a different story entirely. I would put the community on notice that no recordings are allowed, that if it's determined that somebody is taking a recording, the meeting will stop, the person will be asked to leave or will otherwise be removed. So my answer would not change. Now, as the years go forward, maybe some attorney somewhere is going to put something in the governing documents or in a resolution that owners are allowed to videotape or otherwise record the meetings. So you have to look out for that also.
And we do want, Karyn, we do probably want to just note for all of the attendees that there's no express statutory right in any law in the state of New Jersey which allows unit owners the right or members the right to actually take meetings.
Right, there is not.
So I'll address these questions to both of you. How can a board gain control over an emotionally charged meeting? What have you seen that works? Are there any successful war stories that you might share? And do you have any advice on how you handle disputes between board members themselves?
Well, I might have to let Hubert take those because I've never been at a meeting where people have become unruly. If you believe that, I'll tell you another one too. What we typically do, if we know it's going to be a situation where there's notice ahead of time that not just that would be unruly, but it could create a pseudo-dangerous situation, if you will, we sometimes have the board or management arrange for off-duty law enforcement to be present. Sometimes just when members that may be inclined to act out of turn know that law enforcement is planning to be there, either A, they elect not to come, or B, they have a tendency to behave. So I've seen that work time and time again. What are some other alternatives you use?
Correct. I mean, certainly having an off-duty police officer, if the situation calls for a Karyn, we 100% agree with. One of the other issues, and I guess it's more in setting the tone and the tenor of the meeting, especially if the attorney is there, explaining to the members, because oftentimes the very contentious meetings are where there's an emergency or special assessment where people are asked to pay more. I think it helps in setting, obviously in introducing the meeting, just explaining to all of the members that the board members are volunteers. They're up here generously donating the time to make all of the members' community a better community. And that the decisions that they're making, they don't want to raise assessments or they don't want to address this issue. They're doing it for the good of the community. So we always request at the outset of any meeting that we think may be contentious that everyone speak with respect to each other, and we'll try to be as transparent as possible as an association and answer their questions in a respectful manner as long as they ask their questions and behave in a respectful manner.
Yeah, I think you just hit it in that regard. Because sometimes, even though you do lay out that foundation, it's still not going to occur. So what we also like to do is tell board or management ahead of time, if it gets out of control, don't entertain anymore, let the attorney step in.
Correct. And one other point to that issue, Karyn, is if the members get too disrespectful or too out of control, it is within a board's right to ask them to leave. And at that point, they would be trespassing if they refused or became violent. And you could ask them to leave and/or, which I've only had to have to do it once, call the police to have them removed from the meeting, which you do have that right to do as a board. Hopefully, it never gets to that, and you can be respectful.
Absolutely.
Okay, so for those of you in the audience, we know that there are a number of questions that have been communicated to us. We're going to try and go through the topics, and then at the end, we're going to leave some time and walk through some of these questions. So we're going to move to the next section, which is, oh no, we have a polling question first. I am sorry. How does the association you are affiliated with distribute information? Do you use a website? Do you use email? Do you use old-fashioned regular snail mail? And let's see what your answers are to how you distribute information to your members. So 83% of you use mail, and the balance of you use other methods. So our question here, we're still on open meetings here, is what is the best way that you recommend communicating information to unit owners? Is access to website sufficient? If a website is used, then what do you do about those unit owners who don't have internet access? And is email sufficient or is hard copy required? Karyn?
In terms of your question, is access to a website sufficient? The answer is no. There's a number of statutory provisions and also within declarations, master deed, and bylaws where it's actually required that certain things have to be mailed. They may have to be sent by certified mail. In certain instances, you have to post notices for meetings. You have to make publications in a certain number of newspapers, for instance, as to what your meeting schedule is going to be for the year. So at this point, there hasn't been enough change in the language of the law or in the case law that we are seeing developing to avoid the regular means. I know people call it snail mail. I'm still a fan of mail to a large extent because one of the great things about mail is it gives people time to digest, review the information, i.e. notice of a huge special assessment, before the email starts going crazy back and forth. So I would say a website is not sufficient. But with that being said, I would also recommend a website. I would be careful as to how it's created. I've seen some websites where either on purpose or inadvertently, there's executive session minutes that have been published. You do a Google search, and all of a sudden, you've got the back end of somebody's website. You're reading executive session minutes, and they could be talking about litigation strategy. I don't see it happen a lot, but I have seen it on occasion. In circumstances like that, when you're going to provide access to certain sensitive documents, either that should only be given to members or things that are only meant for the board members, you really need to consult with somebody that knows what they're doing to make sure you lock down those privileged materials.
Okay, we're going to move to topic number 2, which is disclosure of association financial information. As a CPA, this is near and dear to my heart. So we're going to put 2 slides together here, and I'm going to ask Hubert to comment first. So many members of various associations and buildings want access to financial information. So here's a group of questions, Hubert, for you to share your thoughts on. Number 1, can owners have access to all financial records? 2, are there time limits or frequency that association record reviews can be implemented? How far back can unit owners go to request information? Can they get the past 5 years, the past 10 years? Do you allow unit owners to make copies of financial records, like bank statements? Can unit owners look at individual receivable records? And lastly, what restrictions, if any, can be put on the review of legal correspondence?
That's a lot of questions, Jules. We'll try to cover them all, though. The primary response is yes, unit owners and members of an association are entitled to review the financial records of the organization. In fact, the New Jersey Condominium Act, actually NJSA 46-8B 14, provides that the association has to maintain accounting records in accordance with generally accepted accounting principles, and that these have to be open to inspection by the unit owners at all times. That would include also specifically the statute's references, a record of all receipts and expenditures, an account for each unit setting forth any shares of common expenses or charges due, the dates thereof, that the due date is, the present balance, and any interest in common surplus. Now, this often comes up with the collection issues. We do not recommend, as a law firm, to publish or release the individual names of delinquent debtors. And I know we're going to cover this later on within our presentation, but we feel that it obviously creates too many potential counterclaims, allegations of slander or libel if the numbers aren't 100% accurate, because it's not a true statement at this point. But it is something that we do recommend that if an individual unit owner requests that you give them, obviously, the unit owners that are delinquent and paid in full with the unit owner information redacted. In addition, there is also the Nonprofit Corporations Act, which would apply to the other homeowners associations, and that statute is NJSA 15A 5-24. It's not as broad as the New Jersey Condominium Act, and it does not delineate the specific financial records that the actual unit owners are entitled to. Now, within the same vein, I will just note that the Department of Community Affairs has given an interpretation with regard to an owner's right to inspect financial records. And the DCA has also indicated that the unit owner is entitled to make copies of those. So the association, if they refuse to provide that financial information, the DCA could enter an order compelling the association to do so, and could actually enter a fine. That is within their purview, and that's one of the areas that they look at. In most situations, we will always recommend that the association be as transparent as possible, especially with the financial information. Of course, I wouldn't give out draft audits or draft financials. The board should be given an opportunity to review and approve that in open session. And once that's approved, you typically always want to give that information to the unit owners and let them know, because it is an association in which they're a member, and they obviously have a strong financial interest in reviewing those records. Just one other a couple of little notes. The New Jersey Condominium Act, if you and homeowners associations out there, but the Condo Act actually provides that costs related to granting owners access to documents is actually a common expense. So you should not be charging the unit owners for review of that information and or photocopy costs. I know we see a lot of resolutions that were prepared by different counsel that does shift that expense to the associations. If the unit owner went to the DCA would probably render an opinion saying that you have to produce those, and you would have to do that as a common expense. Now, I think, Jules, I covered most.
Now, let me just follow up on that. I have a question. When you translate this into practicality, you can't give a unit owner, maybe you can give a unit owner access to these records alone in a room without somebody monitoring what they're doing on a computer system, or are there practical limits that you can impose on somebody so that they can't take up 5 days of a property manager's time in a row? How do you comply with the law and at the same time be practical in terms of being able to run the association?
There's something within the New Jersey Nonprofit Corporation Act, what Hubert had mentioned, the 15A, colon 5-24. Within that, they actually have a section that says a member can access certain types of records upon proper purpose. A lot of times we see that, believe it or not, these document issues turn into litigation. It becomes a mini nightmare for everybody involved. And part of that section of the Nonprofit Corporation Act actually provides that a court as well as a DCA, the DCA is written into the Condo Act, not the Nonprofit Act, a court can compel the inspection or provision of certain documents upon proof of proper purpose. So what we try to do is use that phrase, proper purpose, to show when somebody's request may be overbroad, when it can become a matter of harassment, lack of proper purpose, when it becomes too time extensive, again, lack of proper purpose. So we try to use that to try to gauge what's reasonable and what isn't reasonable with the request, because taking 5 days of a property manager's time is absolutely not reasonable, and the rest of the community winds up paying for that.
Did you talk about how far back you can go if somebody asks? Can I see the last 10 years? Can I see the last 5 years?
Again, I think the associations are entitled to put reasonable restrictions on not only the period of review, but how much time they would spend at the office as well. In other words, if they wanted to take 3 days and review it, I think you could reasonably, as an association, tell them that will not work. You'll be given 2.5 hours to review this. They shouldn't be given unfettered access to those records. Obviously, you would have to pull out any privileged information, and it's taking up a lot of the manager's time to do that, and then you should have someone sit with that person while they're reviewing it. With regard to record retention, and I think that comes in as well, most of the time we look, and there is no statutory guideline other than GAAP, which says you should maintain the records for a period of 7 years. So typically, they could make, a request for records up to 7 years back. Though most of the time, what they would be looking at within those yearly records are the yearly audit, which should be simple enough to obviously produce to the unit owner and let them look at that.
Right. There are some records, in my opinion, that should be kept forever, like the audits and the tax returns?
Correct. Probably more than the 7 years.
Correct.
Tax returns and audits. Were there any other records, Jules? I mean, you don't typically recommend keeping monthly reconciliations.
No.
Okay.
But there might things like engineering studies or
reserve studies.
Reserve studies
And to a large extent, minutes, because minutes make up, or they should make up, the fabric of history of the association.
Okay, let's move on to another topic. The more meetings I've been to lately, the more this topic comes up, and that's collecting owner assessments in this economy. So again, we're talking specifically about board members, not about the collection process and the role of the attorney, et cetera. But Karyn, we'll ask you a few. What steps can a board member take, and what should they avoid to help in the collection process? We've mentioned this before. Can names of delinquent unit owners be made public? And can board members personally call delinquent owners to try and collect money?
In terms of what steps a board member can take and what should they avoid, it's tempting to say they should avoid doing anything when it comes to collection efforts because it's really a quagmire. It's a layer of quicksand. We have certain concerns out there with new laws that are being formulated as to what's said and what's done during the collection proceedings.
That's a fair day collection.
That's correct, that we'd like to keep the board insulated from. But with that being said, there's a number of early intervention methods that boards can use to try to be proactive, whether it's having a policy where they sit down with an owner that calls them in regard to a hardship, upon realizing somebody is, let's say, 60 days delinquent. Instead of the first thing going out is a dunning letter, perhaps it's an invitation to sit down with the board to see if the person really has a hardship, whether a payment plan can be established, because that way you can avoid litigation, you can avoid the weight of litigation, and quite frankly, you can avoid the headache of the attorney's fees if you can't recover them all. In terms of whether the names of delinquent unit owners can be made public, I agree with what Hubert said earlier. I am not a fan of it. For a number of reasons. I think it leads to problems. I know people would like to, for instance, post the name of delinquent unit owners in a high-rise tower, in an elevator. That way everybody that comes in and out can see which of their neighbors are not paying. Okay, well now the serviceman can see it, the cable operator, Mr. or Mrs. Joe from down the street. Now we're making this public outside the realm of the community, and I think that's very, very dangerous.
And you see this at country clubs sometimes still.
You do. I mean, and ultimately, Karyn, I agree with what your contention is. It can often lead to potential counterclaims, because if you ultimately had to institute suit as an association to collect the assessments, they oftentimes will allege counterclaims, and especially if we have other unit owners or service people getting angry in the building, specifically other unit owners, and taking some action to harass those people into paying their fees.
Well,
You'll always have one or two, and then the unit owner can allege that obviously that was the board's result in publishing that list.
And that's right. And anytime you have a collection action now, I've seen a marked increase, because we do the defense work, of counterclaims regardless. So why add that into the pot? Potential slander and Fair Debt Practices Collection Act claims also.
And there's a lot of other ways to address that. As Karyn had mentioned, trying to do it a little softer, getting a late fee notice out, giving unit owners the opportunity to come and amicably resolve. Another thing that's been very successful with some of the associations that we represent are revocation of the rights to use common elements.
And the towing resolution.
And the towing resolutions, which could ultimately be parking, suspension of the right to use a clubhouse or a pool if you have one at your association. So those methods have been very, very effective. We wouldn't recommend taking the risk of publishing a list of names.
So Hubert, let me ask you a few more on the same subject. Any advice on what a board member can do when a bank won't foreclose? Do you have any advice on guidelines for developing policies in terms of dealing with delinquent unit owners? And how important is consistency? And is a board member exposed if they're not consistent? You waive late fees for this one, and you don't waive late fees for that one. And can they get into trouble with that? So couple things for you to comment on.
Okay, we'll cover the first question, Jules, with regards to the foreclosure. Every board should do a business analysis in deciding whether they're going to foreclose or the bank would foreclose. So the first thing you're going to look at, and actually when you file, when an association instructs a counsel to file a lien, your counsel will have to obtain title work first. When you get that title work, it tells you the approximate equity in the property, because you can figure out when that mortgage was taken. Now, if there is equity in the property, the association actually could foreclose and would be almost guaranteed payment, although it is a long process and takes typically about 2 to 3 years in this economic climate. The chancery is very busy. If the bank will not foreclose and they're just refusing, you can either pursue a personal money judgment against the debtor. If they have a job, you can garnish up to 10% of their wages. If they have any bank accounts, you can ultimately execute on those bank accounts. The other option is, and you have to look at the specific judges. We were actually at the foreclosure practice shop. Some judges will not give an association a right to file a receivership. But if they see that the bank is delaying or refuses to foreclose, they will grant the application for the association to have a receiver appointed and then to collect the rent.
That's right. There is a discrepancy depending on what county you're in, isn't there?
Correct. Depending on what judge you're in front of. So you really have to look where your association is. There was 4 chancery judges who were panelists at the speaking, and they were split right down the middle on that precise issue.
I've seen the opinions come down. Yeah.
So you really have to look at what chancery judge and what county you're in. But again, the board should make a business decision on that, because attorney fees, like anything else, it's a business expense that you really have to manage, and then you have a fiduciary obligation as a board member to manage. Guidance for developing policies. We had discussed it a little bit before. You want to make sure that you're complying with the Fair Debt Collections Practices Act. You also want to set forth a procedure commencing with management. So management may want to send out the first 15-day notice, a late fee, second notice at 30 or 45 days, letting them know to pay. Then it may go over to your counsel. You may want to look into revoking those rights. That's been very, very effective at our associations, especially depending on how your association is set up with suspension of parking rights. We typically will recommend to boards to have a standard policy when making payment arrangements. We always encourage the boards to consider entering into payment arrangements. It saves you on attorney's fees, court costs, and other expenses in getting the debtor to actually remit payment. Our initial recommendation is always try to get some money up front, so if the unit owner defaults on that payment plan, that you at least have 50% of the payment that they owe, and then the remaining amounts over a 12 to 18-month period. You should have that some type of standard formula, absent exigent circumstances of true hardships. One of our boards had a kid that a child that had cancer, and the wife had lost their job, and the board made an exception for this one to stay regular with the current regular assessments, and then allow them to commence paying back the delinquent payments in a year. So although you do want to stick to a set formula, I do not think it would open up liability for the board in certain hardship exceptions, though you should document those on why you made those decisions and why you deviated from your policy. So if they ever try to question individual board members at a later date, you have a record of why you made that decision. In addition, if a person is your friend or you have a special relationship with that person, you certainly want to recuse yourself from that vote, because you don't want the allegation coming up later that you showed some type of favoritism in accepting a payment plan or waiver of late fees.
What about waiving of late fees, waiving of fines, waiving of interest? What do you recommend, and do you recommend taking a business approach to this? Do you recommend some money is better than no money if we can get this settled? Do you recommend something different for repeat offenders than the first time? How do you avoid a board being in trouble by making these judgment calls?
You know, again, Jules, you always want to document. You want to have your standard policy, and then they can consider other factors. Most of the boards, if it's a first-time person who's for the first time is delinquent, will waive the late fees if they complete the payment plan or payments, either make a lump sum payment or complete the payment plans all in a timely manner. Fines, it really depends on whether it's a health and safety issue. A lot of the times they will waive fines as long as the person agrees to be compliant with the rules and does so for at least a year. Otherwise, you can reinstate those fines. So it's sometimes meant to just gear the behavior so they're not creating a health, safety, and welfare hazard to the other members. But again, we want standard policies for that, and if we have to deviate from those policies, we want to fully document that so we don't open ourselves up to liability.
Something called selective enforcement, right?
Yeah. Everyone should be treated in a uniform manner, absent circumstances that would give rise to a different decision.
Absolutely.
Okay, so we're in the community association industry with the emphasis on the word community, and sometimes it's a challenge to have membership buy-in on things. So, Karyn, we're going to talk about membership buy-in. A few questions for you to consider. What's the difference, if there is one, between a regular assessment or a special assessment and an emergency assessment? What's the best way to communicate a special assessment? And what do you recommend to a board if the bylaws require that unit owners approve a certain dollar amount of an assessment?
A very, very popular issue these days, Jules. You know, it should almost speak for itself what a regular assessment is, shouldn't it?
Let's see the monthly.
That's right. A regular assessment is something that's the ordinary, what's its due course per month, something that's set forth in our statutes, what's set forth in your declaration, your master deed, your bylaws. It's what you budget for, and it's what people should be paying so Hubert doesn't have to come after them with the many methods of collection.
So talk about special versus emergency.
There's differences of opinion sometimes with the special assessment versus the emergency assessment. I think, again, emergency assessment should also speak for itself. An emergency is something that you don't have notice. It's not planned for. It's not as if you're trying to bring it under the guise. You're trying to build a capital improvement, but you're going to go for an emergency assessment because you really need that new playground tomorrow. An emergency assessment should be where you have a shortfall. Some type of work has to be done, as Hubert was using the phrase before, for the health and safety and also the welfare of the community. Where we see the most trouble is between the special assessment and the emergency assessment, because sometimes there's not a distinction and there's not agreement between whether something should be categorized as an emergency or special assessment. For instance, we have engineer number A, who tells us these roofs have to be fixed immediately. It's an emergent matter. Board says, okay, let's go out and we're going to do an emergency assessment. Community sits there. They hear that the board's going to do an emergency assessment. However, when the board goes to put this into action, they then somehow call it a special assessment. So then the community gets worried and says, oh, this should have been a special assessment all along. There really is no emergency basis. A special assessment would be to do a project, but you don't need to do it today. You could have planned for it. You could have budgeted for it. You can put it over a couple months, put it over a couple of years. A special assessment should not be a tool for improper or inadequate budgeting, which I'm sure you could talk a lot about, Jules, right?
So what recommendations do you have to communicate either a special or an emergency assessment?
Well, it depends. If you have a web page, it should definitely be up there. If you have newsletters, it definitely should be communicated on the front page, not in the bottom right-hand corner on page 10. Absolutely on your agendas, which are distributed. Are you an advocate of a special meeting to review such items? If it's necessary, it depends what the amount is, what your governing documents call for. If you're going to get a lot of pushback, or is this something that's already been discussed at open meetings for the last year, and there's no questions left? So it really depends on the factual circumstances, Jules.
So since you said the word documents, let's talk about documents. And Hubert, is there a reason today for boards to update, or actually communities, I should say, to update association documents? And if so, what are some of the examples of sections in the legal documents that typically could use updating today? And how are associations obtaining the requisite number of votes to make these things happen?
Well, Jules, I'll tell you, every single governing document is different. It really depends on when the community was constructed. Some documents are very outdated. Other ones that are more recent are not that outdated. Some of the issues that we have run into recently with regards to amendments to documents, one of the issues is tort immunity. Many of the new governing documents include that because we have more insurance claims and themes.
You're getting a big smile out of me on this one. Love the tort immunity.
Yeah, well, Karyn does a lot of insurance defense as well as representing associations, but she does insurance defense for associations. So she loves the tort immunity amendment. Tort immunity means that members cannot sue the association for ordinary negligence. It does take out of the purview gross negligence and or intentional misconduct. But you like to see that. It'll avoid a lot of slip and falls that associations are seeing today and hopefully help maintain your premiums and stop you from being kicked into surplus lines. Some of the, most of the newer governing documents have it, but you have to ensure that the older ones have, if the association has a right to suspend the delinquent unit owner's rights and privileges to use the common elements. Another area that you have to have in your governing documents are capital contributions. You cannot do that by way of resolution, but yet it has to be in the documents with regards to any contributions that are made by new purchasers. Another area is late fees. Your governing documents have to provide for late fees and fines. If they do not, you cannot do that by way of resolution, which is just a board vote.
It's like attorney's fees, right?
Exactly, attorney's fees as well. So another area that I think a lot of associations are looking at is rental restrictions, which you have to be careful with regard, because now, once there is more than a certain amount of rentals, you'll oftentimes have problems financing. So many associations have looked into whether they can potentially restrict the number of rentals and how to go about doing that. And then also insurance obligations as to what the insurance obligations are of the association and the unit owners, and obviously educating those unit owners as to how to go about that. Now, we'll give you some helpful hints on how to obtain these votes. Oftentimes, there's apathy around the communities of getting this done.
It's shocking.
Well, it's sometimes a little different. What we have done, for instance, we had one community, Jules, where we could never get quorum. Quorum was over 50%, and we would have to send out multiple mailings. The problem is it was a larger community, and every time we did mailings, it would cost between $300 and $500. So they were losing a lot of money. What we did was we ultimately took the vote right around pool season, and they had to come in and vote before getting their pool passes, which helped. We also, and we okayed it, they had a raffle for everyone who voted for a gift card for the same price that it would have cost to do another mailing, which was $400. They ultimately ended up getting that passed, and since have only had to do one mailing. So they probably ended up saving that association $1,500 a year just in trying to obtain that quorum.
So this is voluntary voting?
Correct. It's voluntary voting, but if they want to be considered in that raffle, then they would have to do it.
Or use the pool.
Yeah, or use the pool. But we, the board really looked at some outside the box and less legal issues. But now you can't tell them, remember, you can't tell them how to vote on that amendment, but just the fact that they would vote. And another helpful hint is when you go out, a lot of the times the proposed amendments will be in legalese and pages on pages. You want to give them not only the proposed amendment, but a succinct analysis on how this will benefit the community, especially if it will be a cost-savings method. And we actually, in the letter that the association sent in the one particular instance I mentioned, we showed them how many mailings that they had done each year and why it was costing the association a great deal.
Well, since you mentioned the word voting, let's talk for a minute or two about best practices on holding elections. Is there a law that requires secret ballots? How should absentee ballots be handled? And how and when should proxies be used? Karyn?
There is no law that requires secret ballots, but I'm going to give a little disclaimer, if you will, because there are some governing document provisions I've seen in the past, again, whether declaration, master deed, or bylaws, that may have certain provisions within it that the votes should be held confidential, which would be AKA akin to secret ballots. So with that being said, there's no statutory law that I'm aware of, but there could be something hiding in the governing documents. In terms of how should absentee ballots be handled, Well, first, it matters whether or not you have the authority to use absentee ballots. And again, anytime we're talking about election procedures, anything to do with votes, anything to do with notices for election meetings, very, very specific. All the governing documents do have a tendency to have different provisions and requirements. Some may allow proxies, some may allow absentee ballots, some may allow elections to be done by mail-in ballots, aside from transition elections. I'm not going to touch that here. But with that being said, you first have to make sure you have the authority. One of the things that Hubert was talking about, some of the possible areas for amendments to documents, I've seen a lot of communities where they've tried to move to amend their documents to provide for different types of voting, whether it's proxy voting, which is normally done in accordance with the meeting, or whether it's to allow to make permissible mail-in ballots if they don't have that authority.
So in the interest of time, we could talk a lot more about elections, but we're going to go forward here and move to internal board issues and conduct. So Hubert, a few questions for you. Do you recommend that a code of ethics be adopted by boards? And if so, what should be included in such a code? What is a layman's definition of what fiduciary duty means? And any suggestions on how to deal with personal agendas of board members?
Well, that's a quick answer to the last one.
We do actually recommend a code of ethics, Jules. And we do recommend, obviously, that they comply with their fiduciary obligations, which we'll answer, I guess, in a second, that they not disclose any privileged information, that they disclose any potential and or perceived conflicts. Now, one of the questions that comes up, and we have a standard one that we'll use for our boards, we have occasionally run into board members that will refuse to sign it because they have an axe to grind with sometimes the rest of the board. The way you can potentially avoid that as a board is do a resolution, and in order to accept a person's nomination, they would have to look at that board oath of conduct and agree to sign it. Now, if they have reservations about a particular issue, they certainly can raise those, but they're pretty standard board oaths, and it will just go through what the duties are, that they won't take action, obviously, to hurt the association. And you have to remember, too, as a board member, fiduciary duty is kind of an amorphous concept. I mean, what it really means in the simplest terms is you owe the utmost loyalty and to act in the best interest of the people that you're serving for. You're serving as a volunteer, and you're trying to act in the best interest of all of the members of the association. And you're not making a decision for you, yourself, as a board member, but rather for the good of the entire community. Personal agendas of board members. It really depends what we mean on personal agenda. But if you have an interest, any board member should recuse themselves from that vote. And by interest, I mean if you're voting on whether to waive your son's late fees, or you have a best friend who's a contractor that's bidding on work, you should always disclose that potential conflict and then recuse yourself from the discussion and the vote. And it's also important to protect yourself individually as a board member. Certainly, you're serving as a volunteer. All of the board members are generously donating their time, and it's a great deal of work. It's obviously not a paid position, so you never want to take the risk of having even the allegation that you were not fulfilling your duties as a board.
So I'm glad you just mentioned that paid position. So, Karyn, I'm going to ask you a couple things. What information is confidential, and are there repercussions if a board member breaches confidentiality? Can a board member be removed for doing that? I've heard of some associations that forgive assessments for serving on the board. Is there such a thing as a best practice for doing this? And what remedies does the board have if their board member is delinquent in their assessment?
You know, wrapping back to the beginning of our conversation here today, Jules, in terms of what information is confidential, it's the same that would be the distinction between an open meeting, executive session meeting. We would still be looking at the basis for the New Jersey Condominium Act, the Open Meetings Act, and PRED to determine what could be held in executive session for privilege, confidentiality, etc. Those are the things that would be confidential. normally within letters. Sometimes we call them a code of conduct letter. You've used code of ethics, code of compliance. There's different terms people use. Basically, the letter is saying, hey, we need to work together for the good of the community, and these are the things we should and shouldn't do. Normally within that letter, you may indeed have a list of examples of the type of things that should be held confidential, i.e., the example you had before of the draft audit report. Could be attorney opinions as to ongoing litigation, etc. Now, what are the repercussions? That's kind of a very, very hot area because I've yet to see a court fully enforce one of these letters, if you will, or resolutions. Let's say, for instance, it says, $500 fine for each breach of this code of ethics, this confidentiality. I have yet to see a court enforce that type of fine. They may encourage the use of this. They may encourage the person not to expose themselves to a breach of fiduciary duty, which is our undivided loyalty. But in terms of where the repercussions, perhaps it's just a negative attitude or negative feedback in the community. Is there a best practice for forgiving of assessments for board members? Yeah, don't do it. There's no excuse for it. Just don't do it. You can jump in.
I would also check your governing document. Most governing documents, I'd say 99%. I think I've only
99.9?
99.9
Yeah.
Say that board members cannot be paid for the position. I've seen one governing document which was a for-profit association, but it was set up as a homeowners association where they were allowed to pay themselves.
What if the document is silent?
If the document is silent, typically it's an unpaid position under the Nonprofit Corporations Act and the New Jersey Condominium Act.
Absolutely.
And you can't take any benefit or gratuity from being on the board. So there wouldn't be forgiveness of assessments, etc. In addition, you want to keep in mind that even if the governing documents allowed it, you would have to vote and approve that in open session and notice all of the members.
Okay, we're going to do a couple of questions. We only got about 5 minutes left. You got a minute to answer each of these. Is it not a law in New Jersey that people can record a conversation as long as they say they're recording the conversation?
Yes, it is. But you have to notify the other people. Yeah, lawyers are held to a different standard, but remember, the meeting is not a conversation back and forth. It's the board actually conducting business. So that would not necessarily apply. If you're going to tape someone on the phone, you do have to notify them that you're going to do it. But yes, you're absolutely correct.
So in the case of a sale of a unit or refinancing of a unit, sometimes non-members request financial information about a particular association. May or may not be on a website. Are managers supposed to provide this information to people that need it for a refi or for a sale?
Normally what we do is we first get the authority of the owner of the property to release certain financial information because the mortgage companies are requiring that certain financial information be disclosed. We need to have something in writing that the buyer's on notice is okay with it. Not the buyer, excuse me, the seller, the owner.
So most boards get monthly financial packages from the management company as balance sheet and bank recs, etc. If a homeowner wants copies of financial information each month, either given to them or emailed to them, does the association need to do that?
Not necessarily through email, Jules. What you can do is after the board has had the opportunity to review and approve that, you can post it on a website or make those available. It's not, you probably wouldn't have to take the special action to give one unit owner preferential treatment. But it's always our recommendation to be as transparent as possible. Typically, it's an opportunity for the board to show off that they're doing a good job financially, that they're being fiscally responsible with the association's money. And after the board has approved that, we wouldn't necessarily be opposed to, presenting that to the membership or making it available.
Can a board vote to remove a board member for violating confidentiality?
All the governing documents I've seen to date include the provision that it's the membership that elects, it's the membership that removes. Some of the governing documents do give the board the power to remove somebody from their position as an officer, i.e. the president, but it is the membership that calls for the removal of a board member.
In almost all in almost all instances, Karyn is 100% correct with the governing documents. One little trick of the trade that you may want to do when they pass the resolution saying that the board members will execute the board oath, you can say that if there's a violation of any of the duties and obligations, that the board member will agree to voluntarily resign. Because typically the board cannot force them.
Yeah.
Of course, that may end up in litigation too.
Guess what?
But,
yeah. If they don't want to hold information confidential, I don't think they'll voluntarily resign, but here's for hoping.
Any thoughts on situations where a management company hires a board member and the requirement for disclosing that, or whether they can do it in the first place?
If you have a board member that actually gets hired by the association, you'd certainly have to disclose all of those, disclose that to the community. We would think that it would have to be added as a footnote within an audit, and I think most importantly, that board member would have to recuse themselves from any type of vote on that management company. So although there may not be an outright prohibition on it, I don't think it would necessarily be recommended to do that. And if that action was undertaken, you'd certainly have to take the steps to protect not only the board member, but obviously the association, and making sure that that board member recuses themselves from any type of votes or discussions involving the management company that's serving them.
Okay, I would like to thank both Karyn and Hubert for a wonderful discussion that I found stimulating. I thought this was great. Their contact information you can see on your screens right now. We appreciate your participation in our webinar today. When you get your survey, please return it to us so that we can get some feedback on what you liked and what you didn't like and what you might be able to like to see in the future. I will also remind you that this webinar is being recorded and will be available on our website if you want to forward that link to others who missed it. And have a very pleasant day, and thanks again for tuning in.
Thank you for your time.
Thank you.